'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Mike D coming down for sure.
Worked on determining what's actually in the contract through differentiating terms from representations and then also differentiating conditions from warranties in terms. Now, there's a special kind of term in a contract that we also want to cover briefly in this subject, and that's disclaimers. So first, we're going to look at what a disclaimer is, and then we're going to look at three broad kinds of philosophies or approaches that the law uses. So we will use some specific cases, but I want you to get an idea about how disclaimers work if you're ever dealing with them, rather than to know the specifics of the law. And if you understand that, I think you'll understand that the traps behind using disclaimers. Okay, so let's have a look at what disclaimers actually are. So for some very good reasons, business might try to eliminate or limit risk or their liability under a contract. And they do that by disclaimers, which can also be called exclusion clauses, exemption clauses, or limitation of liability clauses. It doesn't matter what they call them, the same principles are going to apply. So what it does is it limits the rights of one of the parties to the contract. So they won't be able to sue for a breach of the contract despite the other party not performing what they should do under the contract. Now, as you can imagine, this is a difficult thing because the whole point of having a contract is that you can rely on them fulfilling their contractual obligations, right? So disclaimers are, not controversial isn't the right word, but they're a paradox, right? Why would you have a disclaimer in a contract? Because the whole point of having a contract is to obligate someone. So because of this, the courts use the contra proferentum rule. So that's Latin, right? And all it means is it's going to be read against the person seeking to profit from it. So any clause, any term or provision will be what they call read down or read narrowly against the party trying to rely on it. So the courts are really trying to limit the effectiveness and scope of disclaimers. As we've said, the courts evolved this rule so that it wouldn't erode the rights of a party who wouldn't discover it until it's too late. It often, particularly in the modern economy, we also note that there's a power imbalance in negotiations. For instance, if you go into a telecommunications provider, you can't really negotiate. So you have to accept the exclusion clause if you want the contract or the goods or services. They're called standard form contracts, right? And so because of this tendency as well, the lack of an ability to negotiate, courts have increasingly read down disclaimers. So in BSB 151, we're going to look at three aspects of disclaimers. So for a disclaimer to be effective, it must be part of the contract. It must be a term. Disclaimers are interpreted narrowly, and we're going to use one example of this, the four corners rule, as an example of how they get read narrowly. And disclaimers can't be misrepresented. Okay, so there's three key things that we want to look at. So let's go to the first one. Disclaimers must form part of the contract. Have you ever wondered why the signs for a disclaimer about not being liable for loss in a parking station are before you get to the boom gate? This is the reason that we're dealing with right now. For a disclaimer to be effective, it must be incorporated into the contract. That means it needs to be a term of the contract. Now, for it to be a term of the contract, we have the situation where if it's in a signed written agreement, Lestrange and Graucob tells us it's part of the contract. But what about those situations where we don't have a signed written agreement, right? You must be given reasonable notice of the disclaimer. There's lots of cases on this, but the best way to think about it is you've really got to know about the disclaimer before you enter the contract. Now, we know from our work on offer and acceptance that you enter a contract in automation, like at a parking station, when you take the ticket. So if the disclaimer was after you took the ticket, it wouldn't be part of the contract. It has to be before you take. That's the only way you can learn about it before you enter the contract, right? So that's why they are where they are. So you must be given reasonable notice. And the case for that is Thornton and Shoe Lane Parking. I won't go through the detail of that case, but it's essentially that point that if you don't get the disclaimer before you enter the contract, right? If you enter the contract before you actually learn about the disclaimer isn't effective because it's not a term of the contract. You haven't been given reasonable notice. However, the exception to that is if you have regular dealings. Oh, that makes it a bit tricky. So for instance, just say you went to a parking lot and you went there every day for 3 weeks. And in the lift, after you've entered, park your car, and in the lift, there's a disclaimer. Well, over 3 weeks, you would have read that, right? You would have read it. You would have seen it numerous times. So therefore, one way you can be given reasonable notice is if there's repeated dealings and you've seen the disclaimer as part of that repeated dealings. So that's kind of a little tricky exception. Balmain New Ferries is our case for that. I'm not going to go into the detail of these cases, just purely so we don't overwhelm ourselves in this part of the course. But they're good authorities. You can look them up if you want. They're very interesting cases. But they're all about this idea that the disclaimer must be incorporated into the contract. So the next one is, I am going to go into the case of Sydney City Council and West to look at this particular issue. So there's lots of ways that the disclaimer gets read narrowly, and we don't have the time to go through all of those rules, and it's a bit overwhelming. You don't need it for business law. But we're going to deal with one rule that gives you the sense of what's going on, and this is called the Four Corners Rule. Now, what do we mean by Four Corners Rule, and what is it? Let's have a look. So the Four Corners Rule, it's an unusual kind of phrase that the judge came up with that is stuck, and all he's meaning is the four corners of the contract. Okay, so within the contract. A good case for this is the Council of the City of Sydney and West. So what happened in this case? Well, a guy parked his car, right, in a parking station that was run by the City of Sydney. Okay, and while he was away, someone stole the car. Now, of course, as all parking stations do, there was a disclaimer that they wouldn't be liable for loss, including theft. So there's a clear disclaimer, and the disclaimer was in the right place, so it's part of the contract. And so on further investigation, what had happened was the thief had stolen the car and had to drive out. When they got to the boom gate area, there was a guy there who you paid, who you gave your ticket to and you paid. And the thief, of course, didn't have a ticket. And so he said to the guy, said to the security guard there, I've lost my ticket. The parking attendant, lost my ticket. The guy said, well, you're going to have to pay full tote odds. And so, as if you've stayed the full day. And so, yeah, the guy pays, whatever it is, $20, well, $60 these days, wouldn't it? $60 for parking for the full day and drives the car away. Okay. Now, what the court held, right, is that was not the normal operation of a parking station. The normal operation is you have a ticket and you give the ticket and you pay what's due. Here, there was no ticket, right, and he paid the full amount. That was not the normal way that a parking station operates. Because of that, it was outside the four corners. And therefore, the council couldn't rely on the disclaimer, right? Could not rely on disclaimer. So the key here is that disclaimer could be read widely to cover any theft or loss that occurs, or it could be read narrowly. And it got read narrowly. It only applies to the normal operation of the parking station. If there's something unusual, it doesn't apply. Here, not having a ticket was unusual. It was outside of the four corners of the contract, and the disclaimer didn't apply. So that principle is very important to understand. We've got the rule, right, which is the Four Corners Rule. Disclaimers only apply to the normal operation of a contract. But there's a general principle there that the courts are always looking for a disclaimer to not apply, because philosophically, right, the reason we have a contract is to put obligations on people, and this gets you out of it. Okay, so the law is balancing your right to agree to what you want to agree to with this idea of what's the point of having a contract if you're not liable for anything. Okay, let's look at our third thing that we're going to look at for disclaimers, which is that disclaimers can't be misrepresented. So the final element is fairly straightforward, that even if you have a disclaimer and you bring it to the attention of the other party before the contract, so it becomes part of the contract, you can't rely on it if the disclaimer has been misrepresented. What does that mean? Well, that means that if you say a disclaimer, doesn't apply to X, like whatever it is. That's an example of a disclaimer. So in Curtis and Chemical Cleaning and Dyeing Company, someone brings in a jacket to be dry cleaned, and I think it had beads on it, and there was a disclaimer that said we're not liable for any damage, and the person behind the counter said something like, "Oh, that disclaimer only applies to dresses, not to jackets, so it's okay." Obviously, you can't rely on that broad disclaimer if someone has said something different that misrepresents what the disclaimer applies to. So I think these days we might see a lot of these disclaimer problems in retail. Say if you you said a warranty applied to a certain thing on an electrical good and said, "Oh yeah, but that doesn't apply to the batteries," right? That's the disclaimer. We cover the batteries, so don't worry about that. And then they try and rely on it. Of course, they can't rely on that disclaimer. They've said that it doesn't apply to the batteries. It's that simple. So there we have it, disclaimers. They're quite a tricky area of law. On the one hand, yes, you can have disclaimers that limit your liability. But on the other, courts tend to look at ways of ensuring that their scope and applicability is read down and limited. They do that by making sure, like any term, it must form part of the contract, right? They must be given reasonable notice. Second, they will read the term narrowly, and we use the four corners rule, the normal operation of the contract, as our way of exploring that option in this subject. And the third thing is you can't misrepresent a disclaimer and say, that it applies in a certain way and then try and rely on a general disclaimer later. Okay, so disclaimers, important parts of contract law. The final thing that we need to look at for contract law is what happens if you don't keep your side of the bargain. Okay, what are the remedies that are available for breach of contract? And we'll do that in the next video.